Imagine you've just signed your first professional contract. It's the moment you've worked your entire life for. Every early morning, every injury, every sacrifice. It all led to this room, this table, this piece of paper. You probably didn't read every clause. You probably didn't even have a lawyer sitting next to you. And if we're being honest, you probably didn't fully understand what you were signing. And that's not a criticism. That's just how it tends to go. But here's what we'd like you to sit with. The law is in that room, whether you invited it or not. And for professional athletes, the law does not show up at the signing table. It shows up throughout an entire career, in their personal relationships, on their social media, in how they are taxed, in whether they can even work in the country they're playing in, and sometimes when they least expect it, in a criminal court. Welcome to Storm Roads' Storm Insights, our audio essay series. In this series, we'll be doing a deeper dives into legal topics, commercial awareness, and the questions the law is still working out. This is for law students, SQE candidates, and early trainees who want more than just a rule. And for today's episode, we'll be looking at the legal world professional athletes actually live in, not from an exam angle, but from the perspective of what it genuinely means to be an athlete, on the contract, building a public profile, navigating a personal life, and operating inside a system that has a significant amount of power over all of it. Let's start at the beginning. So before anything else, the first legal question of a professional athlete faces isn't about money, it's about status. Are you an employee or are you self-employed? That distinction has enormous consequences, and it isn't always obvious. For example, a professional football playing in the English Football League is almost always an employee, with their employment contract, pay-as-you-earn or PAYE, statutory rights, whereas a professional boxer is almost always self-employed. They take their purse, manage their own tax, and have no unfair dismissal rights, no sick pay, no redundancy protection. So two professional athletes, but completely different legal relationships with the organizations they work through. And that employment status question is one of the most litigated areas in UK law right now through the gig economy, agency workers, and sport sits right in the middle in all of that. And even within employment, the sports contract is unusual. It's fixed term. When it expires, the club cannot simply hold you indefinitely. The Bozeman ruling, our European case from 1995 that fundamentally reshaped professional football, established that a player out of contract cannot be held to a transfer fee. They can move freely, but during the contract, the club has significant power. They can loan you out. They can restrict where you move next through release clauses. And if you're coming into the UK from abroad, you're navigating a work permit system that has only become more complex since Brexit. European athletes who once moved freely now require a governing body endorsement just to be eligible to play. That legal framework is in the contract before the ink has even dried. One thing that doesn't get enough attention is the legal structure around athletes, not just the legal issues that before them. Take the agent relationship. Most professional athletes have one. Agents negotiate contracts, manage commercial deals, and sit at the center of some of the most significant financial transactions in sport. They are also structurally in a position of potential conflict. An agent who represents a player while maintaining a financial relationship with the buying club is operating on both sides of the same transaction. FIFA regulations and the FA rules attempts to prevent this. Dual representation provisions exist precisely because that problem is recognized. But the relationships are layered. The financial arrangements are not always transparent, and the conflicts of interest are systemic rather than exceptional. And agents are just one part of this. Governing bodies present their own set of structural tensions. The body that regulates your sport also disciplines you. It can suspend you, fine you, and worse, end your career. Under procedural rules that don't always mirror the protections you'd have in a court of law. The Court of Arbitration for Sport in Lausanne is the final forum for many international disputes. It is not a court in the conventional sense, and athletes who reach it are frequently navigating a system they didn't know existed until they needed it. Now, let's say something happens. An allegation, an arrest, an investigation. It doesn't have to involve the sport at all. It could be entirely personal, but it becomes public. The criminal justice system operates on a presumption of innocence, but the employment contract does not have to. Most high-value athletic contracts contain morality clauses. These are provisions that allow a club or sponsor to suspend and, in some cases, terminate a relationship if an athlete's conduct is deemed to have brought the organization into disrepute. That conduct doesn't require a conviction. In some cases, the allegation alone is sufficient to trigger a contractual response. Bail conditions add another dimension. If an athlete is on police bail pending an investigation, those conditions might restrict their movement or require regular reporting. None of that is compatible with a professional sporting schedule. The criminal process and the contractual one run in parallel, and they don't necessarily lead to the same outcome. An acquittal in a criminal court does not automatically restore a commercial relationship. Those are governed by different standards, different thresholds, and different decision makers. And then there's privacy. Athletes are public figures, but the courts have consistently held that public status reduces, rather than eliminates, a reasonable expectation of privacy. So where exactly that line sits is still being worked out, case by case. Now, let's say you've established yourself. People know your name, sponsors are calling, and here's what it gets interesting. Because being a professional athlete and being a public figure are two different identities, even when they belong to the same person, your name and likeness have commercial value. And the question is, who controls them? In England and Wales, there is no dedicated right of publicity the way that there is in parts of the US. Athletes here rely primarily on passing off the principle that an unauthorized use of your name or image could mislead the public into thinking you endorse something you haven't. It's not exactly straightforward or have a watertight protection. It requires proving reputation, misrepresentation, and damage. And it's also expensive to enforce. So what tends to happen, or what good legal advice would look like, is that image rights are separated from the employment contract entirely. An athlete might have a personal service company holding their image rights, with a separate commercial agreement licensing those rights to the club. That creates a different income stream, different tax treatment, and a different layer of legal exposure. Your kid's sponsor is one brand. Your personal sponsor might be a direct competitor. What you post on Instagram, what you wear on your own time, what causes you publicly support, all of that is now routinely governed by social media conduct clauses written into contracts. A professional athlete's right to speak publicly is not the same as yours or ours. It is contractually constrained in ways most people in other professions would find extraordinary. Just like in our previous episode, and for the rest of the series, we always want to highlight questions that may not be asked or thought of. So, our first question is around employment status. In professional sport, it is largely decided by contractual structure and working arrangements. But as sports organizations experiment with shorter deals, performance-based models, and new athlete arrangements, who benefits from keeping that status ambiguous? The organization or the athlete? Next topic is around morality clauses, which allows clubs and sponsors to act before any legal finding has been made. That protects commercial interests, but does it also create a mechanism for powerful institutions to punish individuals based on an allegation rather than fact? And is the athlete ever in a position to meaningfully resist that? Third are image rights. Image rights companies are a legitimate tax structure. They are also a way of moving income away from the PAYE system, which is pay as you earn. HMRC has challenge arrangements it considers artificial. At what point does tax planning become tax avoidance? And who in an athlete's legal team is responsible for that distinction? And last but also bonus question is around the agents. If an agent is financially connected to both sides of a deal, who are they actually working for? Professional athletes are often described as people who do extraordinary things with their bodies. What's rarely said alongside that is that they do all of that inside an extraordinarily complex legal framework. One that governs their work, their image, their speech, their personal conduct, and their ability to earn a living. Most of them don't fully understand that framework until something goes wrong. And by then, the law has already been making decisions on their behalf. Thank you for listening. We hope this got you thinking about sports outside of the conventional sense and linking it to law. Consider subscribing to the channel, leave a like, and drop a comment on which topic stood out to you the most. Stormnets, zero fluff, pure knowledge.